Hey, hello everyone. Thanks for coming today. I'm Robin Whitaker, Vice President of the Canadian Association of University Teachers. And just for those of you who don't know us, CAUT was founded in 1951 and is a national voice for over 72,000 academic staff, including teachers, librarians, researchers, and other academic professionals at some 125 universities and colleges across the country. CAUT's members are researchers and educators, and as part of our teaching work, we use, share, and assign to students materials covered by copyright. CAUT's members are also creators of materials in which, by and large, we own our own copyright. These would include, among others, research publications, monographs, books, articles, and data sets. That makes us both users and creators of works, which gives CAUT members a distinctive and I would say balanced perspective on copyright. As such, we obviously believe that fair dealing is an important user right that has a role in ensuring this balance. We've, for a long time, been an advocate, along with the Canadian Federation of Students, for fair copyright laws on behalf of the education sector and the Canadian public. For well over a decade, CAUT, along with the Canadian Federation of Students, has intervened at the Supreme Court of Canada and the Federal Court of Appeal at landmark hearings that have all ultimately affirmed the importance of fair dealing user rights of educators, students, and researchers. So looking ahead, it seems likely that along with all the other things that AI is changing, that artificial intelligence will bring unprecedented changes to many aspects of society and our lives, including in the education sector and the work done on our campuses. Over the past few years, the federal government has engaged in consultation on copyright and artificial intelligence. CAUT has contributed to these consultations. The current government has also tried to pass artificial intelligence legislation. It does seem unlikely at this stage that Bill C-27 will become law before the next election, but doubtless the next government will need to continue wrestling with questions around AI, copyright, and fair dealing and research. All of this makes Dr. Carys Craig's presentation today particularly timely, and we're very glad to have her here with us. So by way of a brief introduction, Dr. Craig is professor at Osgoode Hall Law School at York University in the field of intellectual property law and technology. She's been a faculty member at Osgoode since 2002 and was a founding member of IP Osgoode, and she's now director of that since 2023. She's author of scholarly publications on relevant issues to the talk today and is regularly cited in legal arguments and judicial opinions, including notably in several landmark rulings by the Supreme Court of Canada. She's received multiple awards recognizing her teaching and service. And Dr. Craig holds a first-class honors bachelor degree of laws from the University of Edinburgh in Scotland, a Master of Laws from Queen's University, and a Doctor in Law from the University of Toronto. So I'm very pleased to welcome Dr. Carys Craig for Canadian Association of University Teachers and the Canadian Federation of Students celebration of Fair Dealing Week this year. So over to you, Dr. Craig.
Thank you so much for that kind introduction, and many thanks for having me here today. I'm very grateful to CFS and to COAT and to Andrea Stewart and the organisers of this event for the invitation to be here. Fair Dealing Week is kind of an important week in the international calendar of copyright geeks, at least, which I count myself. And it's always just an honor to contribute in some way to this annual celebration of user rights. And it's particularly nice to be celebrating with the CAUT and CFS, which have, as you suggested, been so instrumental in advocating for fair dealing in Canada's education sector for so many years. So with that, I was given free rein really to decide what to talk about today, so long as I mentioned fair dealing. But it was suggested to me that I might want to touch on AI since it has become such a hot topic in copyright policy circles. and, well, the world at large these days. And it has become as well something of a preoccupation in my own work, I have to admit. And so I really actually welcome the opportunity in this context to begin to sort of connect the dots here between fair dealing, user rights, and artificial intelligence, because I do think that the sudden sort of disruptive arrival of generative AI has really thrown the politics of fair dealing into flux once again. So my broad contention is going to be that the fate of fair dealing and AI are very much bound up with one another right now in ways that may not be entirely obvious, but that a healthy fair dealing defense is going to prove vital to the direction of the technological development that we're seeing, to AI research, the development of AI tools and technologies, not just for generative AI, but for data analysis and informational analysis of big data as well. But also, I think that the way that AI develops and its position in our whole knowledge ecosystem might prove really critical to the health of fair dealing and user rights and the copyright system as well. So what we're seeing now, I think, is in the politics of fair use and fair dealing, this sort of shifting landscape around generative AI in particular, and that's causing a bit of a backlash against fair dealing and copyright exceptions. And so this turn, I think, against fair use in public discourse, this strategic retrenchment of strong and restrictive copyright controls is politically opportunistic, but I will contend ideologically misguided. It's serious though. So now really is a critical time to be doubling down, I think, on the importance of fair dealing in the academy and why it matters perhaps now more than ever. So with that, there's a lot to cover. We have an hour. I'm going to take you through a sort of history and development of fair dealing, a bit of a fair dealing 101 recap on where we are and why it matters for those of you who are perhaps less familiar with that history. So settle in. Here we go. First of all, as part of the fair dealing primer, when we're using language of copyright exceptions, which we tend to use still in the copyright context, I like to start with a quick note about baselines and where they are. We might use the language of exceptions, copyright exceptions, to describe fair dealing, but it's important to remember that in the grand scheme of things, copyright protection is the exception, right? The natural baseline is that ideas and information and cultural works belong in the public domain. Copyright grants limited rights over original works of authorship for a limited period of time, granted not sufficiently limited now that we have a term of protection of the author's life plus 70 years. Thank you, America. But anyway, limited. And so I think we can imagine, and this sort of visual might help you to do so, that the public domain really is the shared commons. It's like the ocean of information, knowledge, ideas, and works of expression. Copyright's private control in this is the exception, right? It's the island. It's bounded by the public domain, which is the default. And then even within the island, as you can see, there are areas, there are activities and inlets and pools that aren't part of the land that copyright will not control. And all of this together, when you look at it this way, creates a balanced ecosystem, right? That's the goal. For our purposes, a balanced cultural and knowledge ecosystem in which creativity and authorship, expression, research, education, and learning can all thrive. So when it comes to ensuring the sustainability then of this copyright balance, some of you are no doubt aware, but some perhaps not, that for the past 20 years, Canada's jurisprudence really has been, as Justice Abella put it, citing Myra Tofik, at the vanguard, right? Canada's Supreme Court is at the vanguard of interpreting copyright as a balance between copyright rights and user rights. and its understanding of fair dealing is no exception. Fair dealing, according to the Supreme Court in this York University case, is one of the tools employed to achieve the proper balance between protection and access in the Copyright Act. So if we put that in context, it follows that to understand and apply fair dealing means understanding the copyright balance, right? And understanding that copyright law isn't only about protecting authors and owners, but also and equally about the public benefits of the system, copyright's public interest goals. And understanding this is the crux of the Supreme Court of Canada's modern fair dealing doctrine. Okay, so recognizing that fair dealing allows copyright to function as it should, to advance the public purposes of the copyright system rather than to defeat its own ends. This is key to understanding fair dealing. It's also perhaps, I think, equally important to understand that it was not ever thus, that this was something that was fought for. So Canada, as a Commonwealth country, has a fair dealing defence that was inherited from the UK from its 1911 Act, which infamously or famously codified and crystallised a sort of court-born fair use defence into a fairly narrow statutory exception for a limited number of purposes. And these purposes, which you can see here, were also then quite rigidly interpreted by the UK courts and then the Canadian courts as well, on the basis that they were sort of exceptional derogations from the copyright. So since its enactment in 1921 and for most of the 100 years that followed in Canada, fair dealing was raised, if it was at all, as a defence only to be summarily sort of dismissed pretty much out of hand. When I was writing my master's thesis on fair dealing in Canada, kind of at the turn of the century, not to age myself, fair dealing hadn't been ever successfully pled in a Canadian court, at least not when it would otherwise have been an infringing use. So that's the context. The evolution that we chart is typically traced back to the landmark case of Théberge in 2002. And that's where the court first appreciated the nature of copyright's purpose as being this balance, right? The balance between promoting the public interest and the encouragement and dissemination of works of the arts and intellect on one hand, and obtaining a just reward for the creator on the other. And the court here stressed then that this means giving weight to the limited nature of creators' rights and avoiding the kind of excessive control by copyright holders that might prevent works from being appropriately used and appropriately built upon by others in the public domain. Then we have, of course, the fateful 2004 CCH decision. And this is where the Supreme Court recognized that fair dealing was a user right and gave it that language, gave this public interest element of the law a positive weight that could equal that of the owner's rights in this balancing act that we're performing. So we were told user rights are not just loopholes. We're told they need not be read narrowly. They should be given a fair and balanced reading and not unduly constrained. And as for, what was fair, we were told that this is in itself a sort of a contextual assessment, thinking you have a large and liberal reading of the purposes, and then you engage in this contextual, multifactorial assessment of fairness tailored to the unique circumstances of a case. So looking at the purpose and the character of a particular use, the amount that's been used relative to that purpose, what alternatives might have been available, the nature of the works that are at issue, and the effect of the dealing on the plaintiff's work. Okay. Then coming out of that, in 2012, we had the famous pentology cases, which were really a sort of concerted effort, or born of a concerted effort anyway, by the copyright collectives to try to, amongst other things, get the court to step back from this position on user rights, this language of user rights. And instead, what we saw was that the Supreme Court kind of doubled down on it. It reiterated fair dealing is indeed a user right. Classroom copies were found to be fair. Music samples were found to be fair. And the court insisted that as well, when faced with these new technological uses of work in the digital environment, that its role was to ensure the balance between authors and users should be preserved. And that's a concept that's understood to mean a technologically neutral approach to understanding copyright and to applying copyright policy in the digital age. Okay, now it's worth remembering or stressing that the ruling in the Alberta and Access copyright case, that was the one that teachers making copies for their students are engaged in fair dealing, that was decided on a pre-2012 Copyright Act based upon fair dealing for the purposes of private study and research. But there was an amendment in 2012, the Copyright Modernisation Act, added more purposes to fair dealing, including education, as well as parody and satire. And so we have seen, and predictably, we saw something of a backlash at that point to these developments, right? We have lobbyists, publishers, copyright collectives in Canada and around the world actually trying to rewind those 2012 amendments in particular, trying to argue that education shouldn't have been added to the fair dealing provisions, that it should be removed, that it's emboldening educational institutions to engage in what it was called rampant infringement. But the real change, to be clear, was never the addition of the word education in 2012. The real change had indeed come about 10 years before with Tay-Bird, with this recognition of copyright's balance, and then in CCH with the recognition of fair dealing's role in ensuring that balance. Okay. As for what that so-called rampant infringement by educational institutions looked like, of course, we were thinking about the fair dealing practices in the education sector. And this led to the York University and Access copyright litigation, which lasted for a long time, but has, don't worry, a happy ending. So here I'm talking about educational uses, fair dealing practices in the education sector, which combined with purchasing of books for libraries, licensed database access, transactional licensing by schools and universities, all allow for teachers to teach effectively and for students to access educational materials for learning purposes. In other words, for universities to do what they're supposed to do and for copyright to work in the way that it's supposed to work, in a balanced and functional way that avoids defeating its own ends. Admittedly, with this Access copyright case, there was some concern that the court's approach to fair use would be unduly narrowed in response to this litigation and the lobbying tactics that accompanied it, that the collective society, this is Access Copyrights Collective Society that licenses reproduction rights in literary works. It had priced itself out of the digital market, essentially, with costly, onerous, opaque licenses for educational institutions. At least that would be my position. York and many other universities had opted out of paying the tariff and found themselves on the wrong side of this litigation. York argued that it was free to opt out of the tariff. It counterclaimed that its fair dealing practices were in line with its guidelines, that these were fair dealing based upon the court's jurisprudence. At the trial division, we had a really problematic ruling suggesting that York was just trying to get for free what it used to pay for. And the Federal Court of Appeal, in fact, agreed, essentially on that point at least, with that the institution's perspective was the perspective that mattered for assessing the fairness of the use rather than that of teachers or students, and it too refused to find fair dealing, although it did agree with York that the tariff was not mandatory. So that's where we were when this went to the Supreme Court, and happily, well, first of all, I should say a lot was obviously at stake, right? We had actually a significant slate of interveners involved, from authors guilds and music publishers on one side to library organisations, and of course COAT and CFS and the other. It really was all hands on deck. And then in this, what I think of as a happy turn of events and one that's worth celebrating, this Fair Dealing Week, once again, we had a nice unanimous ruling from the Supreme Court of Canada, written by Justice Rosie Abella, that removed any doubt that the Supreme Court remains strongly supportive of user rights in Canadian copyright law. So even although the fair dealing issue was actually moot by now, the court took the opportunity to correct the Federal Court and the Federal Court of Appeal. It insisted that the lower courts had overlooked the nature of fair dealing as a user right, had failed to look at it from the perspective of the user, the student, and suggested that those students' rights could or should be actualized by university practices, right? Because these fair dealing practices at the university are consistent with copyright's primary goals, which include increasing public access and the dissemination of works. So once again, user rights, like fair dealing, are just as vital to copyright's goals as creators' rights. These rights are cast, in fact, as being mutually supportive within the copyright scheme. Okay, so it's tempting to take a breath here just to emphasize and celebrate this remarkable, important landing place in the development of fair dealing in the Canadian copyright jurisprudence. What we're seeing acknowledged is this changing landscape of learning in the digital age, a renewed emphasis on public access, on dissemination, on downstream creative use, that I think solidifies the shift of Canadian copyright away from sort of a focus on purely private interests and commercial control, and towards cultivating this vibrant public domain. But unfortunately, I'm only halfway through the story here, I'm afraid, and halfway through my time, so I guess that's fine. But let's just take a moment of gratitude and then brace for what's to come. Okay, so the backlash again, which will inevitably, of course, continue. So in 2019, we had a Copyright Act review that was generally very encouraging. Cory Doctorow called it surprisingly sensible. And which recognized, I think, the changing demands of access and dissemination in the educational context, as well as transparency and accountability problems that we have with collectives here in Canada. And it also recommended further broadening fair dealing as it happens. Unfortunately, it also included recommendations 16 and 17, which had the effect of kind of keeping the claims of copyright collectives alive in respect of educational fair dealing, and suggesting the need for further negotiation to essentially change the balance that had been reached by the Supreme Court, so that, I don't know, it seems like it's suggesting, together with the budget speech in 2022, that the Supreme Court's balance might be legislatively tipped back in favor of the publishing industry and copyright holders, which would, of course, be to the detriment of copyright users and, in my opinion, the public interest. Of course, Access and Copyright and others continue to call for the government to act on this, and have been trying to mobilize the public with campaigns like I Value Canadian Stories and other such things. And so recognizing this, that takes us to this moment, I think, this precipice on which we stand, staring into the abyss of AI. And I want to challenge you with this question. Has generative AI opened up a whole new front in this long battle against fair dealing in the copyright wars? Right? Is this outcry against AI the thing that might finally spell the downfall of Canada's foray into a copyright system that actually has a robust fair dealing doctrine? Or are we going to try to carry on defending user rights in the age of AI? Are we going to successfully resist what I'm calling the copyright trap in this context? And this is a reference, or what I mean by this is the trap of believing that strong copyright control, that limiting user rights and the public domain is going to rein in the excesses of big tech, that it's going to safeguard our creators and our cultural ecosystem from the threats that are posed by generative AI. And I think that this is a trap in the sense that relying on copyright to control AI training actually aligns with the interests of a small group of powerful industry stakeholders in both the cultural industries and the tech sector, who are kind of happy to draw us into the copyright trap. But I think it's going to do more harm than good to the creators and to the public and the users and the students and the learners who seem to be increasingly attracted to it. And I think once we get drawn into that trap, it might prove impossible to escape. So let me with that now turn to this question and give you the the copyright and AI sort of 101, if you will. You don't anymore need me to tell you about the emergence and the growing ubiquity of generative AI. Everybody knows all about this. We are entering or we're well and truly in what Dan Burke called the age of mass synthetic creativity, or cheap creativity. And we know, of course, that these rapid shifts in technology and in the affordances of new technologies always present a slew of regulatory challenges. And in the copyright arena, Canada and Canadian copyright policy is no exception. It's being asked to respond to the challenge of generative AI. And of course, the reason that for the challenge from a copyright perspective is that ChatGPT and the like, all of these generative AI tools, the reason they've become so powerful so quickly is really because of the vast quantities of data on which they've been able to be trained. And this process of training AI tools or systems involves scraping data, often from the open internet, making machine-readable copies, extracting data and information to allow or to teach the AI. That's the non-technologist explanation, so forgive me for oversimplifying. But you get the point. The input into the AI system is vast amounts of text and data, which of course includes vast amounts of copyright protected works, because don't forget, copyright attaches automatically to pretty much almost every kind of work of art and intellect and authorship that we can imagine. So we are now seeing, of course, the number of complaints about this rapidly escalating. Initially, most of them were being tried in the media, like the CBC story about the Books 3 data set and how it included novels by Canadian authors without their permission. But also now and increasingly in courts throughout the US initially, but also in Canada now too. You can see there, if you go to ChatGPT is eating the world, there's like a running sort of map or list of all of the current cases that are underway challenging the lawfulness of the use of copyright works for AI training purposes. In Canada too, we have now the Coalition of Canada's news outlets suing OpenAI in the Ontario Superior Court for training AI on its news articles, their news articles. And you can look at the arguments here and they're familiar, right? But for the publishers, they're arguing this is an illegal use of their valuable works. OpenAI argues what it's doing is fair use of publicly available data. And note as well that if successful, the damages, if the publishers are successful, the damages could be in the billions. So the question really is, should Canadian law just catch up, as we often hear it said? And by that, it seems to be meant, and start protecting copyright owners like the big media publishers from these AI training uses. Well, as we worry about what the future of AI will bring, there's obviously a growing sense of sort of unfairness. And then this is an accusation start gobbling up human created works, the extraction of value without compensation. And this turns into accusations then of copyright infringement, unauthorized use, and just plain old, of course, theft or stealing. But I think we have to be very careful about this, not just to shore up copyright limits and to safeguard fair dealing, although that's hugely important, and I'm going to come back to it, but also because of the unintended consequences of turning to copyright to protect authors and the public interest in this context. I think it's important to recognize that the quality of AI outputs depends on the quality and the scale of the data on which they're trained, on which the AI tools are trained. So if lawfully training AI requires the permission of every copyright owner, never mind also every copyright author, as some would suggest, of every piece and text and data that's been sucked into that training data set, then that could essentially shut down or foreclose a lot of technological development and innovation. And even if that doesn't sound like such a bad thing to you, which I might even agree with, the question for us is copyright the right tool to be preventing the development of technology in this way? We all know it can be hard to track down the author or the owner of a single work at the best of times, never mind millions of them. And so there's a certain implausibility or impossibility to the request. We also know that copyright, as I said, subsists in almost everything that's written or rendered. And we know that with the kind of scale we're talking about, the sort of damages and risks of liability that could be so astronomical, they quickly become an obstruction or a disincentive to any kind of participation in the development or research of this technology. And I think that's beyond what copyright should be responsible for doing, for regulating. And the actual sort of unintended consequences of relying on copyright control here are pretty clear, right? First of all, some might resort to older public domain sources, which could exacerbate biases in the system, or there'll be a reliance on closed proprietary data sets, which would not be representative of the full sort of breadth of human culture. They'll shut out as well smaller players, leaving them with significant data gaps in their data sets. Or, they'll encourage developers to destroy or disguise training data, which will limit efforts towards transparency and accountability. There's going to be limits of competition in the AI industry, cost prohibitive barriers to competing with the large players who can afford to buy the New York Times data set, etc. Right? You get the idea. This is a way to shore up existing power in the marketplace, to protect the big players who can afford their army of copyright lawyers and their expensive licenses, but essentially to change the course and the trajectory of the development of this technology in ways that I don't think will advance the public interest. Sorry, that's my spiel. Bit of a rant. But what you can see, there's a good example recently, of course, one of Canada's small AI startups is arguably a case in point here. It's now facing a massive infringement suit in the US. So I do think we have to be attentive to these issues, but to bring it back specifically to copyright, we could think as well about this case, which I think is sort of exemplifies the shift that we're seeing here, right? This is a case brought by Canley against Caseway. I'm going to say in the legal field, I could say our beloved Canley is the champion of open access to legal materials, to judicial reasons, and it's suing Caseway AI for claiming infringement of its compiled data for which data that they fought to be free. For them, free for me, but not for thee, right? So if you remember the CCH case, Canley fought to remove access constraints to legal materials in the name of constitutional principles. That was back in 2011. But now they want to be the commercial clearinghouse to supply bulk data for value, while their regular terms of use are actually preventing the scraping and use of these free legal materials, would-be free legal materials, for scraping and for data analysis. So I think what could be a clearer example really of the turn away from openness and user rights and back to closed proprietary control and owner rights with these new technological affordances. So again, I think we have to be wary here. If we want to encourage or just even allow the responsible development of AI innovation, whether for generative AI or just for the sort of bulk data to train systems for research and information analysis, then imposing copyright restrictions seems to me the wrong way to go. So the question then is, well, can we sidestep this then? Can we sidestep this copyright trap in this context? So now we're at the, forgive me, copyright infringement 101, which is just to say it's infringing to, without consent, reproduce a copyright protected work, to publish it for the first time, to perform it in public, to authorize any such acts, or to deal with infringing copies in certain circumstances. So the difficulty is, of course, that a lot of the background work that's done in gathering and establishing data sets for the training of AI does involve the making of copies, digital copies, and the reproduction right in Canada, the exclusive right to make a copy, is cast very broadly. So it's a sole right to reproduce the work in any material form whatever. In 2015, in the Sodrak case, the Supreme Court basically held that any copy is a copy, or at least the incidental copies count as copies and need authorization. That doesn't directly speak to intermediary copies. I'll just place that there as a footnote. But certainly the right is broadly read. I do still think that there are arguments for the position that training data doesn't implicate copyright in the first place. I would argue, well, I mean, we know copyright does not extend to functional elements in protected works. It does not extend to information. It does not protect data, which belong always in the public domain. So to the extent that what is being used and extracted is the information or the data, those are non-copyrightable elements, albeit that they're found within copyright works. Those works become tiny pieces of a vast collection of data. Arguably, the use of each work is de minimis. Or we could just jump to the fact that insisting upon control in this context would upset the balance between owners' rights and users' rights in the copyright system. I'm going to add to this, and I have, that the AI that is using, the machine that's using the copy is not a person. They're not an audience. They're not using the work as a work for its meaning, as a work of expression, only though as a source of data. And so we know that the point of the copyright balance is to leave ideas and elements like information and data free for others to draw upon. I think there's a good argument there that we should create space for the extraction of that data, albeit from a copyright protected source, which is what copyright has always permitted. Copyright does not give control over knowledge or information or ideas. This argument has been advanced in different places, suggesting that the copies that are being made are non-expressive, non-consumptive, shouldn't count. And I think these ideas are very persuasive and should be given much more attention than they have been before we even get to the question of whether there's a fair dealing defense. We should be asking, do you need a fair dealing defense to engage in this, to conduct these activities? And I think the answer there should be probably not. But okay, what if I'm wrong? It's happened. And what if copyright is nonetheless implicated? We should still ask, you know, does fair dealing apply? Is there a user right to engage in these activities? And here I think things look a little bit brighter because of fair dealing, right? The fair dealing defense for the purpose of research, private study, education could conceivably shield what we call text and data mining processes from copyright liability. There are some other routes into it, but I think the most promising one is fair dealing for research. And as we know here, the case law is quite positive and quite promising. We have this idea of fair dealing as needing a large and liberal interpretation, a broad definition of research from the Bell case. We know from fair dealing doctrine and New York decision the importance of access, dissemination, giving users tools for downstream creativity that might enrich society. All of this, I think, could be used to create a compelling fair dealing argument. However, we also know that this requires an assessment of every use, a contextual analysis. There are concerns that we can't really do this at the kind of scale that we're talking about for this kind of use. So even relying upon fair dealing as defined by the Supreme Court may not be sufficient, in the sense that it might still leave uncertainty about the scope of fair dealing, in particular novel contexts, and it might have, of course, just broadly chilling effects on these kinds of uses. And so here we ask whether there's a need for room for some sort of legislative change that would make this clearer, or that would safeguard these kinds of processes. Back in 2019, in that sort of surprisingly reasonable copyright review, there was a recommendation for a specific exception that would clarify or confirm the lawfulness of text and data mining activities. Then there was a public consultation in 2021, and this is the one to which a group of IP scholars, I think 13 or 14 of us in the end, wrote submissions saying this activity probably is fair dealing, but there's sufficient uncertainty that it would be wise to both broaden fair dealing into a general fair use defense, so that you don't need to get through the particular purposes that are listed, and to create an exception specifically for informational analysis or text and data mining. And that seemed to be, that was promising at the time, but as I've suggested, the political ground is shifting quite quickly, and it's tilting away from fair dealing and towards strengthening copyright protections, arguably away from the tech industry and towards protecting cultural industries. Might be one way for us to understand this shift. Because when we saw the second consultation in 2023 on copyright and generative AI, the tone of the consultation paper had changed quite considerably. So it was now focused on questions of remuneration for copyright holders, not whether there should be remuneration for copyright holders, but how much they should get. It was about opt-ins or opt-outs for authors, but not really a suggestion that there shouldn't be either. It was about liability and the appropriate limits of any potential exception that might be added. And so it looked increasingly like Canada was being drawn towards the European approach here, which is to say copyright is implicated, copyright gives strong protection against this unless an exception applies, and those exceptions are quite narrowly or should be narrowly constructed. Also, and I think more worrying, the policy balance or aims were re-articulated, and now suddenly the balance that we were concerned with was a balance between supporting innovation and investment in AI on one hand, and supporting Canada's creative industries and preserving incentives to create by protecting their rights and making sure people are adequately remunerated on the other. So what you might notice here is in this balance of interest, suddenly it's about two industries, both of which are, and the protection of rights. And what seems to drop out the picture in this articulation of the balance is really any concern with users' rights as such, the encouragement of dissemination of works, or the public domain. That whole side of the copyright balance, it suddenly seems sort of invisibilized in these sort of competing industry concerns. So I argued in my submission that fair dealing, again, was probably already applied and should be clarified. I think I have, IPIC made similar submissions, at least that fair dealing already existed and was sufficient to address these concerns. But of course, the usual suspects argued otherwise in their submissions, calling, for example, for the narrowing of fair dealing, for the tightening up of exceptions, for amendments to ensure that text and data mining require permission, require payment. And so I'm kind of afraid to see the statutory reform that might come out of these public consultations if it puts us on the wrong track again, using copyright to restrict these uses on the purported basis of supporting Canadian creators and culture, but with potentially the consequence of really just furthering the economic interests of a few market incumbents in both industries, right? I'm also concerned that the cases, at least in the lower courts that we're seeing, seem to be taking that same path towards copyright control over fair dealing and over the public domain. So the Reuters decision, I think just last week in the US, where they're considering potentially a broader fair use defense than we arguably have here in Canada, and a clearer sort of merger doctrine, Semaine doctrine, those doctrines that protect the public domain in the US, were nonetheless sort of read down and essentially dismissed in what is really not a promising decision, although perhaps not one that's going to set the course for what's to come. Okay, so where does that leave us when it comes to fair dealing and text and data mining in the academic context? Just a couple of words on this, and I want to finish up quite quickly. Of course, my eye on the clock here. But you know, there is a group of researchers. I belong to this research network, working on protecting a right to research in the international copyright system. And we've been cautioning that the failure to create a safe space for text and data mining and informational analysis could significantly hamper innovation and could limit access to knowledge for research purposes. We also note that in law and socio-legal studies and many other fields, history, journalism, politics, AI systems can be used, health, to conduct important computational research and informational analysis. So this is just one example. A colleague of mine who's using AI tools to extract data from online federal court dockets to identify patterns of outcomes in thousands of immigration cases. And so Sean Rehag's work emphasizes how machine learning can be used to pursue this kind of empirical research. It would have been impossible to do a few years ago. But he too is running into like the Canley terms of use that foreclose this kind of computational analysis because it prevents you from accessing the data that you need to run the analysis. So I think and hope that I've mounted here a kind of full throttle defense of fair dealing and user rights and public domain, even in the era of generative AI, in spite of, or actually in part because of, the concerns that I share about the rapid development of AI technologies. And I fully recognize that my position is becoming more controversial by the day. And I can imagine you thinking, you know, well, can't we do both? Can't we have both? Can't we have our cake and eat it too, right? Support fair dealing for education and research in the academy, but insist that text and data mining is copyright infringement for when it comes to generative AI, for example. And my answer here is like, I don't think so. I don't recommend it, right? When you look at the parties who are lined up to impose copyright constraints, here they're the usual parties. They're the same people, the same actors, the same collectives, the same industries who have opposed fair dealing in the education sector, who've used the protection of creators as the sort of rhetorical tool to advance their self-interested arguments. So I think if we lose sight of why fair dealing in the public domain matters now, that will become a self-inflicted wound. I think now we need to fight for fair dealing more than ever. So I'll just say, if you're interested in this, I've shared a forthcoming paper of mine on the copyright trap, where I basically suggest that a combination of moral panic about AI and a complacency about the social costs of imposing copyright control has brought us to this policy precipice, right, where we're about to fall into a copyright trap. And ultimately, I caution, pointing to what Jessica Littman wrote about the 1990s copyright wars, that there's a certain copyright hubris here if we assume that copyright control should be the thing that makes the rules of the game when it comes to the future development of AI or any other technology. Not just because of the problems it poses for the future development of that technology and its implications for our culture, but the threat that this stance would pose to Canada's fair dealing doctrine and to the public domain that we fought so hard to protect. So with that, I'll end. Thank you very much.
Thank you so much, Dr. Craig. And I was so excited about your presentation that I skipped ahead of the technical notes from Justine de Jager of CAUT. So I'm going to turn that over to her right now to fill that in, and then we'll just have a few minutes for questions and answers. And I see that there are a few already in the questions and answers panel. So go ahead, Justine.
Yes, no worries. It's mostly concerning the Q&A anyway, and you seem to have figured it out, folks, so great job. But we did also want to acknowledge, of course, that, so I'm calling from the unceded, unsurrendered Algonquin Anishinaabe territory, and while this webinar is, of course, virtual, we do encourage folks to reflect on the territory that you are on as well. And yes, so for the Q&A, there is a button on there's an icon on your toolbar. You can click on that and enter your question there because we are in a webinar format. And finally, we just want to preempt the question. Yes, slides will be available in French as well after the webinar. And that's it. Thanks very much.
Thanks so much, Justine. Dr. Craig, I'm not sure if you're able to see the questions. I'll just read out the first couple and you can decide where you want to start. So the first question is from Alistair McRae, and it's, is not using copyright in relation to AI training a slippery slope? Patent protection allows industry to thrive rather than stifle it. And then the second question is from an anonymous attendee. That's a bit of a tongue twister. Thank you for this information, Carys. Are you able to offer a perspective regarding effective application of Creative Commons, other open licensing, traditional knowledge licenses, etc., in relation to fair dealing, the emerging AI environment, and how authors might effectively maintain their creator rights? And I'll just read finally the third one that's in there. Is it possible that exceptions for machine rights, if those succeed in gaining recognition, might provide a basis for expanded fair dealing for non-machine readers? And when we get through those, if we have time, I'll get to the others. So over to you.
Okay, thank you for the questions. And yeah, I can read them as well. So I'll try maybe just to pick up on what's been asked as well as the themes they present. So I do take the point that wherever we're at a precipice, right? So there's slippery slopes all around us, and it's not to say that refusing to use copyright is going to create the sort of perfect regulatory environment for AI development either. I understand the question seems to be pointing to the other tools, the other intellectual property tools that might be used in lieu of copyright. So a reliance on patent law, perhaps I think even more so reliance on trade secrets. And I think those concerns are real. The truth is, I suspect people, when they're asserting the rights, would always assert as all of them anyway. So at least I think taking copyright out the picture at that early training stage would be helpful and beneficial, regardless. I also, I would encourage people that even if you're not persuaded that this shouldn't be a copyright problem, to think about, well, if we were going to create some sort of safe space for this kind of training in the copyright system, how could we do that in a way that we can ensure it actually creates public benefits and helps with sort of transparency in the development of a AI for good. And that might mean actually requiring things like opening up data, requiring transparency, and requiring sort of the sharing of the underlying algorithms and so on. And so if you want to be free, or if you to do this, then you need to also be sharing. And that kind of digs into that kind of Creative Commons idea, right? Like you have the benefit of using it, but then you have the obligation to give others the same benefit, to pass that forwards, if you will. And so that takes me, I guess, to the other question about using Creative Commons, open licensing, copyleft approaches in relation to fair dealing, both to, I guess, assert authors' rights and to create space for downstream use of them. It's a complicated question and not one that I have time to answer exactly. I do want to say, though, that I think, the advocates of copyleft, the advocates of Creative Commons are themselves having a bit of a, if not an existential crisis around this, then certainly a very serious debate about whether openness can be, how to ensure that openness is used for good, and what, when you open something up for sort of others to use commercially in sort of technological tools that you might otherwise want to resist, is that advancing the sort of politics that initially inspired the open movement? I think these are all really important questions for us to grapple with. I just worry that we've skipped right over them. We've just jumped right over them to the enforcement of copyright control, to throwing fair dealing out the window, to accepting the idea that knowledge and information can be owned and controlled, which is, an absolutely radical stance and departure from foundational copyright principles. And so I want to begin from the sort of foundational copyright principles and the copyright balance and recognition of user rights, and then have these conversations about how best to help that copyright system construct a sustainable landscape for the good, sound development of AI technology. Let me check. I can see the questions as well in front of me, but I'm not sure if I can read them in time to be helpful. I encourage everyone to read the questions because they're excellent. To understand correctly, let me take this question. The words can be considered data, and data is not copyrightable, so the mining of data is working in the public domain. No, my suggestion is that the way that the material is being used is to extract data points, that the copies that are being made for training are never getting to the public. They're not consumed by or read by a human. So in that sense, it's not even like the incidental copies in the Sodrak case, which ultimately are copies of the works that are broadcast. These are copies for the machine for the purpose of basically turning the meaning in the text into maths. Like, it's just for the data and statistical analysis. I have to be clear that if what happens at the output stage, and I think this goes to Lisa's question, if what happens at the output stage is that the machine outputs a work that is substantially similar to something in its training data, something that directly competes with the work in its training data, then that may very well still be an infringing use. So if it's the outputs that are seen by the human user or are shared with the public that are substantially similar and that therefore unauthorized copies of works, then the copyright law applies to them and fair dealing as it always would. It's the input stage where the copies are only for that computational process that I don't think we have a reason to insert copyright control in there, apart from to produce a kind of windfall for certain copyright owners and to give new life, I think, to certain copyright collectives.
Thanks, Carys. I think if you want to take a few extra minutes, we can continue with one or two other questions if you're not in too much of a rush, and understanding that some participants may have to leave, but up to you.
Yeah, no, thank you for the opportunity. I might just say a little bit about the last question because it's short enough for me to read efficiently, which is, I mentioned that not applying fair dealing rights to generative AI would also harm creators. Can I enlarge on this? So I'm saying both that, I don't think applying it is going to help creators, and that might be the main point because that's one of the main sort of policy arguments that's being made. At the scale at which we're talking, the idea that somehow money or fees could be funneled back to individual creators of content in a way that makes a significant difference or really any difference at all seems impossible. The scale means that the transaction costs involved in this process, never mind the intermediaries involved in it and their interests, mean that this is not really an intervention that's going to help creators anyway. And then I also think, this is a creative tool in a way, and I think allowing copyright to prevent people from engaging with or from using new kinds of technological tools to assist them with their creativity could be detrimental. And I think as well that if you're relying upon closed data sets that have been licensed to train AI, I think I suggested there was not everybody's going to be included and reflected in that. So I think you're going to end up with tools that basically reflect and regurgitate dominant sort of hegemonic culture and exclude a lot of voices as well. So it's that kind of like foreclosing creative opportunities for downstream creators, limiting creative tools, and closing the universe for so many of other voices and participants by sort of limiting the cultural domain on which these tools can be trained to things that have been licensed by the big players.
That's great. Thanks so much, and for your flexibility at the end as well. And it was a wonderful talk and very, very helpful. And we will be, of course, looking forward to reading the paper that you posted and following your work in future. And yeah, many, many thanks for this presentation today and your continued excellent work on the issues.
Thank you so much, Robin. I appreciate it. And thank you again for the invitation to be here. I know this is a complicated area and there are lots of feelings about it. So I thank you as well for the excellent questions. I'm sorry I couldn't get to them all, and I look forward to continuing the conversation.
Okay, thanks, and bye, everyone.